hearing, looking away at both sides, it's because we generally have screens in front of us, and we may be looking away at the briefs or whatever. Okay, well, welcome to the last case on today's docket. This is case number 123380, Russell versus Kansas Department of Revenue. I'm Karen Arnelberger, Chief Judge of the Court of Appeals. I'll be the presiding judge today, which simply means I'll keep time. To my right is Judge Henry Green, the longest serving member of our court at 28 years. To my left is Judge Michael Boozer, who has also been a long-serving judge on this court for 16 years. So you have a lot of experience, at least on each side of me here, and we look forward to hearing your arguments. Because this is on YouTube, I would like the appellant, I'll give them about 2 extra minutes, if you will start out and just give a general overview of what this case is about, just so somebody who doesn't know anything about it will generally get an idea of what we're talking about. And then I'll start your time. So I will call the case, and well, I've already called the case. I'll ask for the parties please to enter their appearances.
May it please the court, the appellant Darrell Russell appears by and through counsel Bruce Mayfield via our Zoom video platform.
And did you wish to reserve any time for rebuttal, Mr. Mayfield?
I do, Your Honor. If I could reserve back 3 minutes, please.
Okay, will do. And for the department?
May it please the court, Donald Cooper appears for the Kansas Department of Revenue.
Okay. With that, Mr. Mayfield, you can begin.
Thank you, Your Honor. As a general overview of the type of case this is an appeal from a district court trial which held a de novo trial following an administrative proceeding with the Kansas Department of Revenue. It's an administrative driver's license hearing appeal, and the facts are fairly general as they go as far as DUI cases. There's not a whole lot unique about it. And I think as a practical application, and I would suggest served about 12 years for the Department of Revenue as a hearing officer, and so we would see a lot of these hearings in this vein. Mr. Russell was driving his vehicle at 12:30 in the morning. It was a snowy night. He was stopped for a basic speed rule by a police sergeant in Overland Park. Shortly thereafter, a backing officer, Officer Neff, appeared to take over the investigation, did field testing, and arrested Mr. Russell. It's important to know some of the facts here, that all through the process of him being tested and dealing with the law enforcement officers, all the testimony of the officers and my client was there. He was cooperative, he was polite, he participated, he followed instructions, he got along, and he went down to the station. When they were at the station, the officer gave him the standard Miranda warnings that we're all pretty much used to. And then immediately after that, provided him a DC-70 notice, which is the implied consent advisory. And our legislature says that if we're going to take a alcohol test from a subject, we're going to give them some advice about what's important. And what's interesting is in this particular case, in the facts of this case, Mr. Russell didn't say yes, he didn't say no, he said nothing at all. He remained silent. In fact, the officer at some point, even the officer at trial indicated that he believed that when he gave a Miranda warning, which was given prior to the DC-70 notice, and the DC-70, the implied consent advisory notice, we'll get to that as we go, but he said he was not being combative and he was just being silent. And the officer said that what he perceived on the Miranda is that people do have a right to remain silent. So when he got to the question, will you take a test? He said, you need to give me a verbal response. And Mr. Russell didn't. He just continued to look at the officer and continued to be cooperative. He asked him to open his mouth as he began a 20-minute observation, and he was cooperative, did so, and then came back again and said, would you take a test? And he just sat there and looked at him, making eye contact, remaining silent. So that's really the facts, underlying facts that bring forth this appeal, Judge. We had a district court hearing, and at that point, we file our appeal. And Judge, the appeal is basically on 3 points. There's a case. The first point was going to be on the Standish decision. The Supreme Court addressed a case. It was in 1984, and in the facts of that case, for the last 20 years while we practiced law in this area, at least I did, I've always interpreted this case about how you rescind a refusal. If you've said it, how do you unsay it while you're still in police custody? And we all wrestled with this issue. And I never really understood some of the import about why the notices changed, because I was kind of in the middle of that as a hearing officer for the Department of Revenue during the 80s and 90s, when we were this case was kind of a seminal case. Well, the facts of this case shows up, and I'm reading this opinion, and it's really all about Miranda. It's about when you get confused, that there needs to be some precautionary advice given. If the officer is going to give you Miranda, he can't say you can do this and then turn around and say you can't do that without giving some explanation. So in the Standish case, Mr. Standish said he wanted to talk to an attorney. Miranda, he was just told he could. So the officer gave him a while to look for one, but go figure, an attorney didn't respond to his phone call at 2 o'clock in the morning. And that's understandable. And at some point, the officer said, this is too long, and called it a refusal. But then the court, further in the opinion, said, but you know what, this kind of confusion, well, it's a reasonable confusion. And we're not going to say that it's appropriate to suspend your driver's license because you were confused by the information the officer said. Well, immediately thereafter, the Kansas legislature modified KSA, and it changes in the statutory framework, but 81001 essentially says that if you're going to arrest somebody, you got to give them these advisories. That immediately thereafter, they said, you don't have a right to an attorney. And then it went on to say you have certain constitutional rights and privileges. And the old notices that were given, essentially, I did some legislative history in my brief, but they put in phrases like, you don't have an opportunity, the opportunity to consent to or refuse a test is not a constitutional right. I'd give you some notice. And then in 2017, the year before Mr. Russell was arrested and provided notice, the notice was actually said you have the opportunity to consent to or refuse a test is not a constitutional right. They give you that precautionary advice after being given Miranda. And then it said there is no constitutional right to consult with an attorney regarding whether to submit to testing. Well, the next year, the legislature just stripped all that out. They just said you don't have a right to an attorney. Well, that notice was right and appropriate for Standish because he wanted an attorney. But they didn't address things like you have a right to remain silent. The other advisories that the Miranda decision has delivered essentially did not have that safeguard. And so,
Mr. Mayfield,
yes.
Let me ask you a few questions here. Did your client
have we started his time yet?
Oh yeah. Oh yes, absolutely.
Thank you. I'm sorry.
Did your client refuse to take the breath test?
No, Your Honor. My client chose to remain silent and provided no verbal or visual response to the question, will you take a breath test?
So he remained silent when asked if he would take the breath test.
He did, Your Honor. And
the reason, and we do have law that silence can be an indicator that it is a refusal to take the test.
There is law that says silence can be a refusal to take a test, but they did not raise issues about whether or not Miranda was before or after, whether there was a need or requirement for precautionary advice once you tell somebody they have a right to remain silent. I mean,
let me ask you this. What was the evidence as to the reason that your client remained silent and didn't answer the officer's question about the test?
at trial, my client indicated he was confused, believed the officer when he said he had the right to remain silent in regard to questioning, and he did so. The officer himself said he wasn't being combative. I think he was just remaining silent. And my client also testified he thought he probably would have passed the test had he been not confused by his right to remain silent.
Well, here's what I want to ask you about is in that you asked your client at the hearing, were there any advisories that caused you concern? And his response was, if you refuse to submit to and complete the test, or if you fail, your driving privileges will be suspended for a period of at least 30 days and up to a year. So it was, if you do or you don't, it's the same penalty. In answer to your question about confusion. And then he followed up by saying, it's somewhat common knowledge that if you refuse, you've got more problems than if you don't. So to hear this saying, if you do or you don't, it's the same penalty. It's like, okay, here's an officer of the court. I'll take this as guidance. In other words, it seems to me that the evidence at the hearing was, his confusion was, I'm sitting here, the officer's just told me, if I don't take it, I'm losing my license. If I do take it, under the circumstances, I'm going to lose my license. So I'm just not going to say anything. Having nothing to do with any confusion about whether he was going to remain silent or not in taking this test.
Your Honor, in the context of the testimony that was provided and knowing the rest of the facts of the case, the confusion was whether his license was going to be suspended for a year or 30 days, whether he failed or whether he refused it. The legislature, the next year after this DC 70 notice was provided, split those two things out because it was so confusing. That's a different answer to the question that you just asked, because if you look at it, they bundled together both if you fail or if you refuse, you could lose your license for 30 days or a year. And when he said he was following the officer's advice, it was his right to remain silent.
Well, yeah, because my understanding is that your main argument is his refusal was by silence, and it was reasonable given the confusion presented by having the Miranda rights and then having the advisories. And I don't see that in that particular section of the transcript. But let me ask you this. Did he ever specifically invoke his right to the Fifth Amendment or his right to silence? I don't believe he did. Do you have any counter information on that?
And maybe I'm not familiar enough. My primary practice is not criminal constitutional law, but I'm not sure of the case law that requires a subject, once they've been Mirandized, to have an official statement or some marking in the record that says they do accept it. I think if they choose to talk, they're at their own peril, and if they choose to be silent, I guess they're following the rights that were afforded to them by the officer in the Constitution.
So in answer to my question, did he ever specifically invoke his Fifth Amendment rights? To your knowledge?
Yes, and when you say invoke, I guess I don't want to testify here, but are you suggesting that he say he was going to do it?
Let me rephrase it.
Sure.
When he was asked any questions by the officer, did he say, "I'm invoking my right under the Fifth Amendment to remain silent," or the equivalent? I don't want to say anything because of my constitutional rights.
That's fair. I don't recall that being in the record. No.
All right.
I don't.
Now, would you concede that your client answered several questions after he received the Miranda rights and the advisories? He answered several questions posed by the officer.
In respect to whether he wanted a drink of water or but nothing to do with whether or not he would agree to take testing. No, Judge. Well, I can't agree to that.
He was asked 2 times as far as about, do you still remember your Miranda rights? He nodded yes, which would be an assent.
Okay.
And then he was asked if he wanted to answer any questions, and he verbally responded, no.
Oh,
And then he was given the DR 70, and the officer said, I'm going to read it to you. And after his Miranda rights, he said, I don't want to, or I don't want you to. So I guess my issue is, it seems like he is making statements throughout here that are saying yes, no, whatever. I want a drink of water, where he was not remaining silent immediately after getting both the Miranda rights and the advisories.
Well, Judge, there, and I'm wanting to say it was in Leroy, State versus Leroy, kind of following up on the Supreme Court case Schmerber versus California, where we were making a distinction between what is a Miranda, statement, whether it's communicative or whether it was related to something substantive, or the type of testimony that would otherwise be protected by Miranda. I think those are. Do you know where the bathroom is? Do you know I'm here? I mean, I think they're not questions that Miranda, and if you were going to invoke, that doesn't mean you don't respond to those kind of questions or the housekeeping questions. Did you hear my notice? I mean, well, yeah, I think that goes right along with the subject who's not drunk.
You want to take my test?
No, well, who is not?
No, I don't want to take your test.
Well, but he was being polite and cooperative, and that goes right along with, well, I'm not going to talk to you.
And he can certainly be very polite and very nice and say, no, I would prefer not to take your test.
Well, that's probably advice I give to citizens, but that isn't always the facts that come in your office.
Let me ask you this. The court made a specific finding. He said the Fifth Amendment issues are not applicable when it comes to the testing. This is a direct quote from the judge. Mm-hmm. Therefore, the plaintiff, Mr. Russell, could have submitted to the testing and remained silent, could have nodded his head, could have extended his arm for whatever equipment was necessary. He could have exercised both. He could have remained silent and submitted to the test. I just like, give me your best argument against that finding.
Well, I guess the best equivalent to that would be having a murder subject in your interrogation room and say, don't tell me how many, show me by how many fingers people you killed this week. And you maybe hang up 3. Well, that's testimonial. That's a violation of Miranda if they've been advised or not advised. I mean, I suppose it's if they did that before they were being advised. To put out your hand is testimonial. But I got to tell you what's different about this is that the refusal act itself is an element of the crime. And that's what's a little bit different. We're not talking about a test. We're not talking about a test result. We're talking about a statement. Because if you refuse a test under Kansas law, it's one more, it can be used against you as a part of the underlying offense that they're intending to prosecute you for. So it's a trick bag. The Fifth Amendment's not really applicable, except if you consider that a refusal is, tell the jury that he refused it, and you may consider that positive inference that he was intoxicated. I mean, that's self-incrimination. And there was I want to say I quoted I can't pronounce it, Wotan, and it talked about the doctrine of unconstitutional conditions, and it said that essentially people shouldn't have to decide between 2 different constitutional rights, and if you do, you should opt for the option that gives you a result. And in this case, I suppose not to give Miranda, because you want you don't want a conflict here. So wait till you get the test, I suppose, before you confuse people. But if you're going to confuse them with giving Miranda, well, we got to give them those post-Miranda precautionary advice that Standish says you got to do. And the legislature did it for 17 or 18 years until the year before, and they just said, we're not going to have constitutional issues. We're not going to advise people that constitutional issues have an impact here. And I do want to make sure this court is aware. I think Don or Mr. Cooper.
You're way over your time now, Mr. Mayfield, and part of that is because we've asked you so many questions, but why don't you save that for your rebuttal?
I will. Thank you, Your Honor.
Mr. Cooper?
Thank you. I appreciate the opportunity to be here today. One of the interesting comments by counsel and basically in his district court arguments and his brief is that he says the appellant states that the Miranda warnings given with the implied consent notices were confusing to his client. However, as statute points out, KSA 8-1001Q, not understanding implied consent notices is not a defense. If you're confused, you're not understanding. That's still not a defense to the allegations here. On pages 8 and 9, the appellant argues that both Standish and appellant were confused after being given Miranda without any further explanation. That further explanation being the implied consent notices. However, here the appellant was given an explanation pursuant to KSA 8-1001. He was given the implied consent notices. Standish was not. That's a huge distinction that counsel has completely overlooked and continues to overlook. And here in this case, the district court judge found that the implied consent advisories that followed Miranda satisfied the Standish requirement of, quote, further explanation. District court did this twice because counsel for appellant filed a motion to reconsider, which the district court also denied, saying that the requirement of further explanation was properly provided here by the officer. Given that the court told Standish that since he wasn't provided the implied consent notices, that caused confusion, the Standish court stated that without further explanation was obviously the confusing part to the accused and Standish. But appellant has argued in his brief, and to a certain degree here today, is that he argues there should be language that there's no right to remain silent should be included in the implied consent advisories. I've looked through the advisories since Standish. There's never been a language that you have no right to remain silent in the implied consent notices in Kansas. Standish doesn't even require that. So, and as I noted in my brief, in the Rubel case, courts are reluctant to add other requirements that are not already in the statute or in law. And that's exactly what counsel here wants this court to do. It's also interesting, and courts pointed this out, that there is no evidence on the record that upon hearing the warnings and then the implied consent advisories, that the appellant was really confused or did not understand what was being asked. What I mean by that is, as counsel stated, the appellant repeatedly stated in his brief and echoed here today, his client was polite and cooperative throughout the stop, polite and cooperative at the station, polite and cooperative at the roadside testing, polite and cooperative throughout the entire ordeal, polite and cooperative when asked to stick out his tongue so the officer could check his mouth. There's no evidence that his client was confused or did not understand what was occurring during this ordeal. In fact, by his own admission, he was polite and cooperative. He understood what was going on. He understood the questions being asked. He understood what the officers were doing. In Kansas, as just a little ago repeated, this issue of confusion was addressed already in the Hampstead case. And Hampstead noted that the court, in that case, the petitioner did exactly the same thing here as appellant. In Hampstead, the court found that petitioner did not exhibit any confusion or ask for clarification. That's important because it sets the standard for an issue like this when you have an appellant or licensee who's been asked to give a breath test or blood test and they remain silent. If they don't exhibit any confusion or ask for clarification, then the only implication and inference that can be made is they understand what's going on and officers should proceed accordingly. Here in this case, the appellant did the same thing. He exhibited no confusion he exhibited didn't ask for any clarification of the warnings or the implied consent notices. He again was polite and cooperative. When he was asked to take the breath test, just sat there being silent. Hampstead also stated that silence has also been held to be constitute a refusal, and they cite several other jurisdictions, specifically Minnesota, California, and Utah. And specifically, Hampstead held that silence was an express refusal to submit to a test. Appellant cites no other jurisdiction, haven't heard anything yet here today that supports his position that silence is not a right during the implied consent process.
Mr. Cooper?
Yes.
As I understand it, the entire colloquy between the officer and Mr. Russell was on a body cam footage, or was memorialized on body cam footage. Is that your understanding?
Be honest with you, Judge, I don't know if it's just a body cam or if there's also another camera or recording device available. I just really don't know. So I hate to answer yes or no.
Because, you know, the one mystery here is after we have the stare down, I don't know if the officer said, you know what, I'm putting you down as a no-show. I'm putting this down as a refusal, or made any statements whatsoever, and we don't have, if there's commentary or whatever. And I note that the judge had a transcript that Mr. Mayfield apparently produced and was admitted as an exhibit that captured some of the conversation, but we of course don't have that on our record. So I was just curious if you knew what statements, if any, were made by the officer after the stare down occurred.
Your Honor, I don't really know of any. I don't.
Okay. Thank you.
Oh, sure. Thank you. The other point I really want to make here is that refusal of the breath test noted by the officer when the appellant did not give any affirmative response to his request. In Kansas, as I think Judge you noted earlier, a test refusal could encompass express refusals, acts, or conduct, which may be interpreted as an express refusal. In McRoberts versus Kansas Department of Revenue, a 1992 case, that's what the court held by one of the panel of the Court of Appeals. So anything other than an affirmative response is a refusal. I don't think that's really an issue here. But express is defined as conveying a thought or a feeling in words or by gestures or conduct. Silence is conduct, no question about it. And in this case, I think any case like this, silence is knowing conduct, absent any information or evidence to the contrary. Here, we don't have any evidence or information to the contrary. What this silence could otherwise mean than a refusal. This case, my argument is this is not confusion that it was being demonstrated by the appellant. It was purposeful knowing conduct on his part. I also want to point out on page 11, I think point 4 in the appellant's brief, he makes a comment regarding the Hampstead court and puts a quote down there. It says, quote, "A refusal can be reasonable if the driver was unfairly confused by the notice and information received contemporaneous with the decision by the driver to voluntarily consent to such testing." I've read Hampstead quite a few times preparing for this. I can't find that language anywhere in Hampstead. So and there's no page cited for Hampstead. There's no other comment or argument to support that comment. So I'd ask the court to disregard that comment and argument. It just has no basis in law or fact that I could find. And as I pointed out earlier, and appellant puts out on page 13, he argues that the implied consent notices make no specific reference to the right to remain silent, and he's exactly right. But then again, neither did Standish, and neither have the, I think, 15 to 20 other DC 70 documents that have been published since the Standish case. None of them have required that language of you have no right to remain silent. And again, several other jurisdictions that I found, a number of them don't require that language in their implied consent notices either. So there's other jurisdictions besides Kansas that mirror what we do. I just sort of want to close here again by stating under the Kansas implied consent law, a person who refuses to submit to or fails to complete a chemical alcohol test in response to lawful request by an officer is deemed to withdraw their implied consent and faces suspension. And also determining whether a driver's failure to submit to test is a result of confusion. I think the critical factor is not the driver's state of mind, but the fair meaning to be given their response to the request that they submit to a chemical test. You can't put the officers in a position where they're going to have to try to read the mind of the licensee in front of them. Is this guy confused? Are they trying to game me here? What's going on? So you have to look at their response. How do they react to that request? Not look at their state of mind or try to interpret or read their state of mind. That's not putting the officers in, they're putting them in an untenable position. And really, when you go back to Hampstead, that's what Hampstead said. There's no acts here. There's no asking for clarification. There's no act of confusion here. They understood what was going on. And in this case, the appellant knew what was going on up until he was asked to do a breath test. All of a sudden, being polite and cooperative, that went out the door. And he wasn't polite. He was, I think, polite, but he wasn't cooperative anymore. So I'll rest there and entertain any questions.
Questions from the panel? Mr. Mayfield, it's your rebuttal, but I do have a couple of questions I'd like to start off with, if you don't mind.
Yes, Your Honor.
So you don't, at least according to the statute, you don't challenge the fact that he was given the proper implied consent advisory pursuant to the statute.
He was given the one for the follow the statute.
Okay. And do you also agree that Miranda warnings are required whenever there is a custodial interrogation, correct?
No, Judge. I think they're a good practice to have those, or the evidence that follows.
Well, but I mean, isn't the long-standing law is you don't have to give Miranda unless you have a custodial interrogation, right?
Fair
those
enough,
are the
Judge.
two. At least those are
Right.
always the two criteria
Right.
I've always learned.
Yes, Your
All
Honor.
right. And we have a long line of cases, including the Kansas Supreme Court in Bishop, which says the request for a defendant to take a breath test does not amount to an interrogation. So if you don't have an interrogation, you can't have a custodial interrogation. So no interrogation means Miranda wasn't even required before he was asked to take the test, right?
I agree, Judge. It wasn't required.
Okay.
And because it wasn't required, I referred to it as gratuitous. We all know that it's important in any criminal arrest situation, but it's not required. You're right. But when they give it to you ahead of time, you got to unring that bell. That's
Right.
why Standish said, if you're going to do that, they actually called, and it was the next case following, and it might have been Hampstead, where they said, essentially referred to it as the Standish warning, almost like the Miranda warning. I mean, where you got to unring the bell once you've given him some.
And add on top of all this the fact that there's a very good chance the person is intoxicated at the time.
Well, it could be, but that's never a defense, and we all understand that. So three things I want to make sure I cover. One, I'd hoped counsel would cover this, but with some of the recent decisions differentiating between blood draws and breath draws, somehow I'm confident that Mr. Cooper, by accident, included in his facts and later in his brief that this was a blood draw and that a warrant was sought, and that this was nothing more than exactly what you know, and that is that he was asked to take a breath test, and that no blood draw was ever taken, and no warrant was ever needed, and no blood was ever, we have no results. Just want to make sure we clarify that if somebody gets in to write the brief and finds some sort of factual distinction, that's not correct. The 10,001 or KSA 81001 Q quote that counsel brought up about confusion's not a defense, it says to these notices that are given. The whole point of this appeal is it isn't the fact that the DC 70 notice, the 81001 advisories weren't given. It was that they were polluted. They were given other information that you just they poisoned the whole idea of giving somebody notice and being fair and a part of due process. So
your position is that the Miranda warning given before the advisory poisoned the advisory notice.
It required a precautionary advice that standard talks about, because, and even in Hampstead, they said, you know what, silence is not is a refusal, but it says, but some refusals under these circumstances are reasonable. I don't think can be found, can be found reasonable. And well, we can review
Mr.
it.
Cooper, I'm sorry, you don't get to react by nodding your head or shaking your head to counsel's argument.
So, and counsel wanted to say that post Standish, any notice is good enough. But the notice that was given was you don't have a right to an attorney, but that wasn't a problem we had here. And Standish went on to say, in the opinion, they said, hey, you should tell them I don't have a right to an attorney. It's in the brief, but they went on to say, also, you should say your right to consent or refuse to take chemical is not a constitutional right. They said that ought to do, and I think in my brief I just said, at least you referenced 2 or 3 things. Constitutional rights were about Miranda. That wasn't just about an attorney, it was other stuff. And all that was stripped out of the notice the year before by the legislature, and it had been in the notice since the time of Standish. So that is very
so Mr. Mayfield.
Yes.
In this case, what additional comments or statements should have been given by the officer either after he gave Miranda and or after he gave the advisories? What would be the statement or the explanation that would have solved this problem?
You're asking me to testify to the legislature next session, because this is what I'm going to say. I think you ought to say, but the rights afforded to you under the Miranda advisory, if you're given that, do not apply to the issue of testing now before us. However, that's better worded, because there is stuff. And when we got into the Birchfield and we got into the Miggs and the Rice cases, that we really got into issues about constitutional ramifications and whether we have the right to consent or withdraw our consent and all that. And I really do think they don't have to say the word for word, what I just said isn't true. But gosh, if you say that, then you've got to give the driver a fair chance that maybe that's not exactly right, because he was doing what he said. And I think the evidence, and Your Honor, when you talk about what evidence is there, the officer himself in the transcript said, I think he was remaining silent. And I think that speaks volumes about what he was doing.
When did you say, Mr. Mayfield, when did you say they struck these constitutional provisions out of the DC?
I put it in my, Your Honor, I put it in my brief, and the year before, I pulled each of the statutory revisions and typed them verbatim. And they're on.
Okay, all right, as long as it's in your brief.
Yeah, it's on page 16, Judge, of my brief. You bet.
Thank you.
And I think, Judge,
you're out of time.
I think I'm out of time.
Most of it.
Thank you, Judge.
Okay, thank you. Thank you very much. It was a pleasure to have both of you argue today. We will take the matter under advisement and issue an opinion as soon as possible.
Thank you, Judge. Thank you, Judge.
Thank you.